Hi there, and welcome back to another episode of Divorce Well in Florida. Again, it's Matthew Waring, and I'm here with my partner, Brian Dunmire. And together we are the partners of Fairway Law Group. We're a Florida divorce law firm. We have two offices. We've got one in Orlando, one down in South Florida. Brian and part of our team is up in Orlando. Me and the rest of the team, we're down here in South Florida. And today we're talking about divorce trials. What are they? Who gets to have a divorce trial, what things people need to do to prepare for a divorce trial, both from the perspective of the case and handling the evidence and the arguments, and also just mentally and emotionally, how to prepare yourself for a trial. If every single case filed in Florida, every divorce case, every paternity case, every modification case, whatever it is, if it's any type of case that gets filed in Florida, if it doesn't settle, it goes to trial. So imagine it like a subway. You're getting onto a subway and you've got different stops along the subway route. The last stop on the subway line for every case filed in Florida is trial. So you can get off on any stop you want before that last stop. But when you get to the last stop, if you haven't got off before on any other stop, you have to get off on that stop. So most cases do not go to trial. Most cases settle well before trial. But the cases that ultimately go to trial, and that's what we're talking about today.
This podcast could be 3 hours. There's a lot of different ways to talk about with trial, but we handle trials. We prepare for trials. We're comfortable in the courtroom, and as a law firm, we'll go to trial. When I'm preparing a case for trial, one of the first things that I'll tell my clients is trials are not Perry Mason, Matlock, Law and Order. Suits is the new one. Trials are a lot of times not even in a courtroom, they're in chambers because it's family law. So you'll be at a table. I mean, literally just a table. You're on one side and your spouse is on the other with their attorney, and the judge is at the end of the table. That's the trial. So first thing to understand is that there's very few gotcha moments. There should be very few, if any, surprises, so to speak. That's just not how the Florida court system is set up. The Florida court system doesn't like surprises. That's not to say there aren't surprises that happen at trial. There definitely are. But that smoking gun moment, that moment that you wait for in the Matlock episode or the Law and Order episode, we've got to disclose witnesses and exhibits well before trial. So it's candidly really boring. It's taking testimony. There's no yelling. There's no screaming. The judge typically isn't slamming the gavel every 2 minutes. It's very, I don't want to say low key, but very mundane compared to what people might think it is in TV and movies. But it's important to understand that it's not this theatrical event or anything along those lines.
Yeah, court orders, trial orders, we call them. When a case gets set for trial, the judge is going to issue a trial order. And in that trial order, it's going to specifically say that we have to disclose all of our witnesses and what they're going to talk about, summaries of what they're going to say. We have to disclose all of the exhibits, every piece of evidence that we intend to introduce. We have to disclose it. We have to exchange all of those exhibits with the other side well before trial. So the other side is going to be completely aware of all the evidence that you're going to present, all the witnesses that you're going to present, and all of their testimony. So like Brian said, there's really no smoking gun moment because everything has to be disclosed ahead of time. And if you don't disclose it ahead of time, then it can be excluded at the trial. So you want to disclose everything. The other thing that makes trials different in family law is there is no jury. The theatrics that you see associated with a trial are usually in the context of a jury. You might see a criminal trial with a jury or a personal injury trial with a jury. And the jury is there to decide the facts. What is true? What really happened in the case? Did the defendant use a knife in the murder? The jury has to make that determination. So there's a lot of theatrics that come into play because you're trying to convince a jury of people to rule one way or the other. And the judge is just there to keep the train on the tracks, to make sure the train doesn't derail, to determine what evidence gets admitted, what evidence doesn't get admitted. The judge is there to apply the law, but the trial is a show for the jury. In family law, there's just a judge. There is no jury. And the judges do trials all the time, tons of them per year. And they've done it for years. So they've seen every kind of trick in the book. They don't need a show. So when you go to a divorce trial, you're not really getting the whole song and dance like you would if you had a jury there. You're just talking to the judge. The judge is deciding the facts and the law. So that makes trials a little bit different in divorce law. The other thing that kind of takes away a lot of the show factor is that the real juicy things in a divorce case, like adultery and lying and cheating, those things don't really come into play most times in divorce cases because it's a no-fault divorce state. We don't need to subpoena the wife's lover to come and testify about the affair. When did the affair begin? We don't need to get into all that in the vast majority of cases. So some of the sex appeal of divorce cases are lacking when you go to trial. And really what the trial is about is the boring stuff. We have to establish incomes. We're looking at tax returns, pay stubs. We have to authenticate those things and get them into evidence for purposes of calculating alimony, child support. We have to get into evidence all of the different marital assets and liabilities. So we're talking bank statements, mortgage statements, credit card statements, 401k statements. Those things have to be admitted into evidence before the judge can rule on them. It can get a little bit spicy when we're talking about child custody. That I think is where it can get a little bit more interesting, so to speak, when we're actually trying to win majority custody for our client. We might have to show it's not in the best interest of the children to spend as much time with the other parent. That requires certain testimony, certain evidence. But in most cases, it's really just nailing down all the finances, nailing down the incomes, and then arguing over certain how the law is going to apply to certain assets and certain liabilities to try to get our clients a favorable verdict. Trial can be very stressful for the people going through it because the power is no longer in your hands. You're relying on a single individual, a judge, to make a determination regarding your children, regarding your finances, regarding your assets, and that can be very stressful. And the judges are trying to make a fair decision in light of all the circumstances and applying the law. They don't always get it right. They might not agree with you on what is fair, but ultimately what they say becomes reality. So everybody going into a divorce trial is rolling the dice. And so when there's risk, there's also anxiety because there's a lack of certainty on what's going to happen. However, there's just no other way to get a case resolved if the parties are not willing to settle. The case has to go to trial. If you don't reach an agreement on every issue, the case will go to trial eventually, and there's just no way to avoid it, unfortunately. Cases go to trial when there's usually one side is being completely unreasonable or both sides are being unreasonable. Brian, how many trials have you been to in which both sides had reasonable expectations?
Um,
Not many.
yeah,
Because if both sides are
both sides.
reasonable,
Yeah,
fair people, then they're most likely going to reach some sort of an agreement.
yeah.
So usually trial occurs when one or both sides have unreasonable expectations as to what they're going to get out of the divorce.
Or there's just a genuine disagreement about something, typically children, time sharing and schedules. It's especially true when the parents don't live like extremely close to each other. 50 miles is a magic rule. Sometimes when the parents are living 40 miles apart, those cases tend to go to trial because it's close enough for a 50-50 time sharing plan, but the schedule might just not work out or whatever it might be. At the highest level, what's super important is if you've listened to our podcasts, we take a very holistic view on divorce cases. If we can get them resolved, we're happy to get them resolved. We don't unnecessarily push cases along just for the sake of pushing them along. When you're working with the other side, whether it's amicably or contentious, we can kind of shoot from the hip, and they can too. The other side can shoot from the hip. Oh, well, this is going to happen, or that's going to happen, or hey, the 6 year old son's saying that he doesn't really like dad's house or whatever. And when we're negotiating resolutions and trying to give a little, take a little, and meet somewhere in the middle, all of that's fine. We can have those discussions. That's not a problem. The big difference with trial, though, is that we have to comply with evidence. Okay. So this is an outdated copy, but I still use it. This is an evidence book. And I will tell you, when I'm preparing for trial, I pull out this evidence book and I reference it. Um, when we're at a mediation or we're just kind of like talking with the other side, anything goes. I mean, oh, well, you've got this bank account, or we think that this account's being hidden, or whatever it is. When we get to trial, there has to be evidence that supports it. And this is one thing that a lot of clients sometimes have a hard time understanding, is that the evidence has to be admissible in some capacity. It's got to be which, and it starts to get very complicated. Okay. Um, there's hearsay. That's the big one that we run into. And the biggest one that we run into is hearsay of minor children. Okay. Florida doesn't have a blanket exception for hearsay of minor children. There's some backdoor ways you can get it in. In very unfortunate situations where there's child abuse or child neglect, there might be an exception for a victim of abuse, that would allow a parent to testify, hey, my 6 year old son said this. The other backdoor way to get it in is to have a guardian ad litem appointed, but I'll also just follow that up by saying they're not appointed in 99% of cases, because guardian ad litems get appointed when there's not good stuff going on. Even when a guardian ad litem is appointed, there's a chance that the hearsay still doesn't come in. So, one of the biggest issues that we run into in trial is evidence and hearsay as it relates to children. So, if you don't have minor children, you can kind of skip over this part of the podcast. If you do have minor children, it's important to understand that your 6 year old is not going to be testifying in trial. And what your 6 year old tells you, hey, I don't like going to mommy's house, I don't like going to daddy's house, is most likely not going to come into evidence because of the hearsay exception. I have my personal views on whether or not maybe there should be another hearsay exception as related, but that doesn't matter because my personal views don't control evidence. It is what it is. So unless there's an exception for that, children's comments are not coming in. Then the next step in that is kind of your everyday hearsay. My child's teacher tells me that when the child stays at dad's house, he comes to school and he's super tired and doesn't focus well. Well, there's all sorts of evidentiary issues with that. There's observations, which probably could be overcome. But you're also kind of talking about patterns. Patterns is a separate evidentiary concern, and you're talking about hearsay from the teacher. So how do we get over that hearsay? Well, the statements either need to be stipulated to by opposing counsel, saying, yeah, we'll just accept those statements as they are, or the teacher's going to have to come in and testify. Well, how do you get the teacher to come and testify? You can ask them real nicely, or you can subpoena them. But when you start subpoenaing people, which is fine, we do it all the time, you might not be super happy that they got to show up to a courthouse. And then there's also, you know, then there's the logistics of the trial. You got to subpoena the witness to be there at the beginning of trial, say 9 a.m. They might not get called until 1:30. So they're just sitting out in the hallway for 3.5, 4 hours. They don't know what's going on because they
Yeah.
they can't be in the room,
And they're not happy.
and they're not happy. So there are absolutely times that you need to subpoena somebody, but at a very high level, a conversation that I have with my clients is, if we have to subpoena somebody to get their testimony because they don't want to voluntarily show up, we might not want them to testify. Okay. And there's always exceptions. There's always, different cases. If we need to subpoena a records custodian from a bank to authenticate some bank statements, I don't really care if they're happy or not. But if you have to subpoena your son's friend's mom to come testify because she doesn't want to voluntarily come testify, you got to weigh some risks and benefits there. Again, when we're in mediations or something, we can say whatever we want. Like, we can just shoot from the hip. We don't have to worry about evidence or anything along those lines. When you get in front of a judge, we have to comply with the Florida rules of evidence, and those are strict guidelines that says what's admissible and what's not admissible, or guides the judge as to make rulings as to what's admissible and not admissible. And the biggest part of that is going to be hearsay. The one exception that everybody should know about hearsay is anything that you or your spouse says is almost certainly going to be a hearsay exception, which means that it can come into evidence to one another. Okay. So if your spouse says, I'm going to take you for every penny because I don't like you, that can come into evidence as long as it's relevant. Everything's based off of relevance too. That can come into evidence. If your spouse tells your friend, I'm going to do this, that does not come into evidence unless your friend testifies to it. Your friend could testify to it. Okay. Then it could come into evidence. That's a hearsay exception that is helpful to know. But just keep in mind, double hearsay exists within hearsay. And practically speaking, that occurs in text messages. That's how we see it a lot, where a friend will text you and say, hey, I just spoke with your ex-wife and she said that she's not going to let you see the kids this weekend or whatever it is. That's double hearsay because your friend told you and your wife or spouse told the friend. So there's two layers of hearsay there that you got to overcome, which is possible. But just these are the things that go on behind the scenes in attorneys' brains when we're preparing for trial is how do we get the evidence in? Okay. As a family law client, you're probably not going to be privy to that until we get closer to a trial. However, what is important is for you to give us the evidence well in advance so that we can figure out how to get it into evidence because photos will need to be authenticated, records need to be authenticated, and sometimes it's easy and sometimes it's not. We've got to identify what exhibits we want to be able to get in. So that's a little bit on the evidence at trial.
And one more thing is a lot of people seem to think that, especially when it comes to custody, that they can go to trial and bring their mom, their best friend, their neighbor to the trial to testify about how great of a parent they are. And they think that that's going to convince a judge to award them more custody. You can't admit that kind of evidence. You can't put on that kind of testimony because that's something called bolstering. And there's an evidentiary rule on that. You can't bring in people to testify at trial about how good of a parent you are. Because I can bring in the whole community can testify about how great of a parent I am and how bad of a parent the other person is. And it's just not going to shake out like that. Let's talk a little bit about what a trial actually looks like. You know, Brian mentioned it earlier. Family law trial, a civil trial or a criminal trial is going to occur in the courtroom with the pews, judge in the robes, court reporter, clerk sitting next to the judge. You got a bailiff right there, maybe two if it's a criminal trial. You got an audience, you got people sitting in the pews, you have the whole jury box full of people. And it's just a big deal. Family law trials are not like that. They can occur in the courtroom. Often they occur in the courtroom. The judge is wearing the robes and there's a court reporter and all that. But there's not going to really be anybody else in that room. It's going to be you, your lawyer, your spouse, their lawyer, judge, clerk, maybe the court reporter. And that's it. Also, these trials can occur, like Brian said, in chambers. What does that mean? That means in the judge's conference room. The judges, a lot of times, will have an office, and inside their office, they have a conference room table. Trials occur there too. And the judge might be in plain clothes. Not like a t-shirt, but maybe a shirt, tie, or dress, or whatever. But might not be wearing the robes. You might just be sitting at a conference table and having to present all the evidence and all the testimony right there. It just depends. It depends on what the judge wants to do. It just depends on the judge's procedures. Here's the other thing to understand about family law trials. Although there is procedures for trials, there are procedures regarding admission of evidence and taking testimony. The judges have a lot of latitude to conduct the trial however they want to do it. The judge does not necessarily need opening statements and full and formal presentation of evidence and testimony. We have been to trials where we're fully prepared to present our entire case, cross-examine witnesses, present evidence, and we show up and the judge might say, all right, well, since everybody's here, let's just disregard the formality. Let's get this situation sorted out. And the judge might just start directly questioning our clients, the parties in the case, and trying to solve a problem. I've had that happen before. It could be very informal, or the judge can insist on having a very formal trial in which you're handling all the evidence as if there was a jury in the room. So, as family law attorneys, we have to be prepared to handle the trial both ways. We need to be prepared to formally present it in case the judge wants to do that day. Or we need to be prepared to present it informally if that's what the judge wants to do that day. It's not always consistent from judge to judge how they conduct the trials, and it's not even consistent when you're in front of the same judge. You might go in front of the same judge who does a formal trial one day and does an informal trial the next day. So you have to be prepared for both things.
Yeah. And there are a lot of judgment calls that we make together with our clients, and then we also make individually as attorneys after talking with our clients. But sometimes clients will think that something is extremely important for the judge to know about because it's important to you. And that's fine. There's no part of me that would ever say that something that's important to you should not be important to you. Okay. You get to decide what's important to you or whatever. But for the purposes of evidence and a family law case, the fact that you paid for new flooring 2 years ago in your house probably isn't going to be relevant to any of the issues. And this is kind of where the issue with family law comes into play is the Florida court system is actually not set up to solve every single issue that you had with your marriage or with your spouse. The court system set up to get you divorced, divide your assets, and act in a manner that the court believes is in the best interest of the children, which you might not agree with after a trial. Okay. That the court did what's in the best interest of the child because, the court rules against you or for your spouse or whatever it is. Judges don't really want to dwell on the very small issues. Okay. So if you're having disagreements as to whether or not the children should be dropped off at the 7-Eleven or the Publix when they're across the street from each other, is that something that we want to spend 15, 20 minutes arguing, taking testimony as to why the 7-Eleven's better than trying to move on with the case and have the judge order one thing or another? And those are the types of things, because I have seen it once, I've seen it 10 times where, we might have a $750,000 house that we're trying to figure out what we're going to do with, or we have a $400,000 pension that we're trying to figure out what we're going to do with, but the parties want to fight over a cat or a dog, and it's not an effective use of time. So we need to identify the big issues and focus on those. It absolutely is your day in court to tell the judge your side of the story, but chances are you're not going to be able to say every single thing that you want the judge to hear, because a lot of the stuff that you might think you want to say isn't relevant to the issues in the case as it applies to the Florida statutes, court rules, procedures, and case law. So trial isn't necessarily this end all be all. I've heard it say a lot of times, well, the judge is just going to see through my husband, or the judge is just going to see through my wife. They're going to see that they're a liar. No, not necessarily. Okay. Because there's two sides to every story, and the truth is somewhere probably in the middle. Okay. Now we'll try our damnedest to win your case. Don't get me wrong, by any stretch of the imagination. But it's important to know that it doesn't necessarily always work out that way. I've won trials, I've lost trials. Any attorney will tell you. And if they can't tell you this, then probably shouldn't hire them. They've lost trials that they should have won, and they've won trials they should have lost. That's a cliche phrase that we throw around in the attorney world when we go to these conferences and stuff like that. Same thing for hearings. You win hearings you're not supposed to win, and you lose hearings you're not supposed to lose. Don't just expect the judge to completely side with you on every single issue, because if that was the case, then no cases would go to trial. Trials are very serious and we have to prepare for them. Okay. And then one other little secret, so to speak, that I tell my clients, and I can say this anecdotally. I was living in Dallas for a little while after I graduated law school, and I wanted to move back to Florida. And so I actually was considering moving to Orlando. Genuinely, I was looking into moving to Orlando, and that's where I live now. And I got called down where I was working at the time in Dallas, and they told me, "Hey, you're moving to Orlando for work." And I was pissed. I was pissed because somebody was telling me that I had to move to Orlando or I wouldn't have a job. Okay. But I had literally already been looking at moving to Orlando. But because somebody was telling me that I was moving to Orlando without that being my own decision, free will, whatever philosophical thing you want to go with there, I was pissed. Okay. Ultimately, I moved to Orlando and here I am and I love it. But at the end of the day, because somebody was telling me what to do and I wasn't deciding it myself, it rubbed me the wrong way. Guess what? It's the exact same thing in trial. Okay. And so, you know, you might be okay with, all right, my wife's going to get half my retirement or whatever it might be. But when you go in front of a judge and the judge says, all right, I'm ordering that your wife gets half the retirement, like, don't be surprised if that rubs you a little bit the wrong way because somebody's telling you something. Okay. Keep that in mind with trial too. It's not really all fun and games or anything, but there are times that we go to trial. I mean, we had a trial a couple of months ago where the wife was adamant that she was entitled to alimony. We're all kind of scratching our heads on our side, like, we could be wrong because I mean, genuinely, I'm not trying to be humble. Like, judges do things sometimes that we don't necessarily agree with, and it doesn't mean that the judges are right or wrong, but sometimes you don't agree with. But in this specific case, we're kind of scratching our heads, like, I don't think there's really any grounds for alimony here. I mean, the claim itself wasn't necessarily frivolous, but when you actually broke down the numbers, we just really believed that our client didn't have any entitlement to alimony. We tried to resolve this case by essentially saying we're not paying alimony up to the day before trial. Like, hey, do you really want to go to trial on this and incur a tremendous amount of fees? And the opposing party said, yeah. And we did. And the judge looks at everybody and says, there's no alimony award here. So we won. So, I say that to say it absolutely can happen. And there's absolutely a time to go to trial, when you believe that the law is on your side and you want to fight for it, so to speak. But if there's just some sort of, little argument that we're fighting over where the drop off location is, an extra $100 and child support for, extracurricular activities, just think long and hard whether or not you want to go to trial, on that.
Judges are not there to punish anybody. That's not their goal. The judges don't care. The judges are not trying to achieve justice from looking at the total marriage and looking at the big picture and saying, well, I think that the husband was not a very good guy. He was manipulative or controlling or narcissistic or whatever, or cheated on her. Therefore, I'm going to rule more in the wife's favor. It doesn't work like that. The judges do not care. I mean, I hate to tell you, they might have their own personal feelings. They might not, but that's not going to factor into their decision. It can maybe jade the judge a little bit. Maybe the judge looks at one party and believes their testimony a little bit more than the other party because of what they've seen kind of occur in the marriage. But when it comes down to dividing assets, awarding alimony, awarding child support, these are mathematical equations. And there's law that applies. Some of it can be gray. That's why we're in trials, because we don't all agree on what the law says or how it applies to a certain situation. But at the end of the day, the judges are there to basically get the math right. And that's for all factors, not including child custody. Child custody is where things can get a little bit more subjective. But really, when it comes to assets, liability, alimony, child support, those are all things that can be decided objectively without emotion and without regard to the course of the marriage or who did what. So if you think that your spouse was a horrible person and that you're going to win at trial and get everything that you're asking for because the judge is going to be able to see right through your husband and think that he's not a very good guy, that's not how it shakes out at trial. Those emotions do not factor into the mathematical equations. And that's something that's very important to understand.
One other thing is a lot of times the case is not over at the end of the trial, which is, something that a lot of clients don't want to hear. And also, I don't like it as an attorney, but it is what it is. So, what do I mean by that? Well, number one, depending on the judges, some judges at the end of trial literally will just say, "All right, thank you very much. I'll issue a ruling and leave." I mean, seriously, that happens. All right. Anything else, counsel? No? Okay, cool. Thanks. Appreciate everybody coming here today and your professionalism. I'll review all the evidence and issue a ruling. And I think under the statute, they actually have 60 days to issue the ruling. I don't know that I've actually, to give judges some credit here, I don't know that I've actually seen it ever take 60 days, but I have seen it take 30, 45 days or whatever. The other thing that I see at trials, this is a little bit more common, is the judges will say, okay, um, I'm going to email y'all the high level rulings that I'm going to make. And then I need you to agree on the language in the final judgment and draft the final judgment for me. And then inevitably what happens is opposing counsel in our office end up going back and forward because there'll be some sort of misunderstanding about one thing or another, and then we've got to order the transcript and hash it out or submit competing final judgments. The other thing judges might do is they say, all right, both sides, please submit a final judgment and I'll review it and determine what it is. And then the fourth one, which is probably what the clients want, is the judge issues the rulings in the courtroom. Okay, here are my findings, take notes. And then attorneys, you go back and draft the final judgments. One thing to be aware of, and it's actually something that we've been focusing on as a law firm here recently, is when we draft settlement agreements, we are really focusing on trying to put contingencies in place if they need to be. Every single case is unique. So, this might apply to your case, might not apply to your case. But the theory is if this event happens, then this second event is going to happen, right? So if the home is going to be listed for sale and it doesn't sell, then this is going to be the next step. Or if the home is listed for sale and something happens, this is going to happen, or whatever it might be. You're probably not going to get that in a final judgment. The judge is going to say, the home should be listed for sale, and upon, the sale, the party shall split the proceeds. Well, guess what? It's not going to say she'll be listed for sale, and if the parties can't agree on the listing price, then, it goes to some sort of special master or arbitrator or something to determine the listing price or anything like that. And so a lot of times there is equivocation. It doesn't necessarily resolve every single issue after the divorce because there might be some, hey, we can't agree on the listing price for the home. What are we supposed to do now? No, I guess we got to file another motion. So Sometimes trial is not necessarily the end of it. Then there's always the possibility of an appeal if a judge just gets something wrong and based off of the standards of appeal. Again, this is why this podcast could be 2 or 3 hours, because there's different standards of appeal. There's de novo, there's abuse of discretion, right? And a lot of stuff in family law is going to be abuse of discretion without, again, getting into a whole class on evidence and appellate procedure. Abuse of discretion isn't just that the judge got it wrong or that two different people could disagree on the outcome. It's that the judge literally 100% misapplied the law and abused their discretion. Very difficult to overcome that. It does happen. Judges get overturned all the time, but it's something to consider when filing for the appeal. Before filing for an appeal, you might need to file a motion for reconsideration, right? So this list can just keep going on and on and on. So, a lot of times, on one hand, trial certainly can be the ultimate, ending of a case. And ultimately, you're going to need to go to a trial and get a final judgment, right? But sometimes that just opens up the next can of worms, especially if there's errors in the final judgment or things that you don't disagree with, or you think that the judge, considered evidence that they shouldn't have, or whatever it might be. So, it just, again, all things to consider if you're close to some sort of resolution or settlement, but there's maybe one little part that you're not in agreement with. Is all of this that we're talking about worth the risk, or should we just pay the extra $15,000, or should the spouse just pay the extra $15,000 in equitable distribution?
We can do another podcast episode on what a divorce trial actually looks like, how it actually proceeds from maybe trial order through pretrial prep to actually how the trials take place, how the evidence unfolds. But I think today what we've done is we've given people an overview of, kind of demystifying divorce trials a little bit and giving people a good perspective on, why they want to ideally reach a settlement instead of go to trial. Because like Brian said, trial it's not going to always go your way. You might win on some issues, you might lose on others. It takes the power and the decision-making out of your hands and puts it in the hands of a third party. And there could also be errors and other things that occur as a result of trial and in a final judgment, which can open up a can of worms. We always try to get cases resolved the best we can. If we can't get them resolved at mediation, we continue to try to get them resolved before trial. However, on the way to trial, we have to continue preparing, because if there's one thing that we've learned through our experience, most often the party that wins, so to speak, at trial or prevails at trial, or even gets the better settlement agreement prior to trial, is the side that prepares the most, that prepares the hardest. So any trial is a gamble. You're throwing the dice. The best position you could possibly be in is to be the party that is more prepared for trial. And that's not just at trial, but that's leading up to trial. The party that prepares the best typically is going to get the better deal. All right. Well, with that, thank you for joining. It's been another episode of Divorce Well in Florida. Again, my name is Matthew Waring. I'm here with Brian Dunmire, and we are at Fairway Law Group. And we appreciate everybody listening to the podcast so far. And if you could, give it a like, give us a review. We appreciate the feedback. And if anybody has any suggestions, feel free to put that in the comments. Thank you. Have a good day.